Hi, my name is Vincent Rosillo, and I'm a partner in the law firm of Feinall and Andaman. And as part of our ongoing service to our clients, we prepared this short video to talk to you about your hearing. By now, you've received that notice of hearing, and if you review it carefully, it will tell you the date and time and the location of your hearing. Please be sure to contact us when you receive that notice of hearing. Do not assume that we've already received a copy and will be there for you. Be assured that we will attend every hearing that you have. An attorney from our firm will be with you throughout the hearing for every hearing that you have going forward. You will not have to go through this process alone. You should know that the Workers' Compensation Board schedules hearings for a number of reasons. It could be that this is your first hearing and the board wants to determine if your accident was caused by your work. Or it could be to determine whether you are totally or partially disabled and how much money you are entitled to receive. Or whether your doctor's request for surgery or physical therapy should be authorized. And in some instances, you will have a hearing to finalize your case to determine if you suffered a permanent loss of use and if you're entitled to compensation going forward, and if so, for how long. The notice of hearing indicates the reason for the hearing, but you should be aware that in reality, the Workers' Compensation Board can address any issue that concerns your case. They're not limited to just what's on that notice of hearing. Now, with regard to the hearing itself, they're usually very brief, probably won't last more than 10 minutes, and they are relatively informal. Although they are informal, a recording is being made just in case either party wants to file an appeal. The hearing is presided over by a workers' compensation law judge, and someone from the insurance company, a representative from the insurance company, will be there as well as you and your attorney, someone from our office. If you are unable to appear at the hearing, whether that be virtually, in person, please be sure to call us and advise us. There may be times when the judge would like to call you, so make sure that you give us the correct phone number and you can call in for your hearing. If you are able to attend the hearing, if the board permits in-person hearings, be sure to look at the notice of hearing for not only the location of the hearing, but the part number, P-A-R-T. That number is the room that you have to go to have your hearing. And when you call us, you should make sure you tell us all that information. If you are able to attend the hearing, you should attend the hearing 15 minutes in advance so you can talk to your lawyer. In every instance, whether you're appearing virtually, by telephone, or in person, and the attorney assigned to your hearing will contact you prior to your hearing to review your case. If for some reason you are not contacted by the attorney a day or two before the date of the hearing, please reach out to us so that we can go over the hearing prep with you. One of the common questions we get is, what should I wear at a hearing? And the answer is, it's an informal proceeding, so business casual is appropriate. You don't have to wear a jacket and tie. There will be instances, though, where the judge does set aside time for you to testify, or a co-worker, or a witness to the accident. And if that's the situation, you will be asked questions by either the judge, by our office, or by the insurance company representative. If the judge doesn't set aside time for you to testify, in most instances, you will say very little at the hearing. I know it sounds frustrating, but there is a very limited amount of time, and we are there to make sure that your point is made before the judge. There may be times when we don't have much to say because we believe the judge is going to issue a favorable decision, so there's no point in going on about a particular issue. Please don't expect us or the judge or the insurance company representative to review documents that you hand in that day. The day of the hearing is not the time for you to submit requests for reimbursement for travel or medical records or records of your reduced earnings or work searches. Those documents should be given to your attorney well in advance of the hearing. The judge may just adjourn the case if information is just provided to them on the day of the hearing. The lawyers, the judges talk using terms that you probably will not understand. Most of it is acronyms and shorthand terms for medical terminology or legal terminology. Don't be frustrated by the lack of understanding. After the hearing is over, the attorney will explain to you the hearing results and what your next steps are. Again, I want to thank you for placing your trust with us. And if you have any questions, please be sure to contact your legal assistant or managing attorney. Thanks again.